So let's talk a little bit about the regulatory aspects of this and staying ahead of the curve so that you can build practical systems that'll keep you on the right side of the law, the bar, and your client's expectations, because the regulatory landscape for AI is constantly changing. It's unpredictable, but there are some existing guideposts that we can use to navigate it safely if we're paying attention to them. So right now, the AI regulation is really patchwork in the legal profession. There's lots of different pieces that don't always match up perfectly. The ABA has been busy issuing guidance. State bars are weighing in. Courts are starting to establish precedents. I mentioned the ABA's 2023 formal ethics opinion on cloud computing. While, again, it doesn't specifically address AI, its principles about due diligence on technology vendors, data security, and client confidentiality apply directly to AI tools. Now, several state bars have issued specific guidance on AI use, Florida, California, and New York in particular, but you'll have to check your home state to see what's going on with your own bar. The federal court system is weighing in. Some federal judges have issued standing orders requiring disclosure of AI assistance in briefs in motion. Again, the trend is clearly towards more disclosure and oversight, not less. And then internationally, the EU AI Act creates strict requirements for AI systems used in legal contexts, including transparency, oversight, and bias testing. While that primarily applies to EU-based activities, it could affect U.S. attorneys working with European clients or on cross-border matters. The key to navigating this regulatory environment is building these solid internal systems that exceed current requirements so that you can prepare for the future as things evolve. The first is a tool approval process, like who decides which tools the firms are going to use, your firm is going to use, and what criteria you're using for evaluation, how these decisions will be reviewed. And then second is protocols, which tasks are appropriate for AI assistance, what verification steps are required, and when human oversight is mandatory. And then the third is client communication, when and how to inform clients about AI use, what level of detail is required, and how to handle objections or preferences. Training is absolutely critical. Everyone who uses AI tools needs to understand not just how to operate the technology, but why the ethical guardrails exist and how to implement them effectively. Create training modules for different roles. For example, partners need to understand liability implications. They need to understand client communication requirements, while associates might need more detailed guidance on verification procedures and quality control of the output, and support staff need clear protocols for data handling and confidentiality.